Greetings, great day. Hello, welcome to the Life in Transitions YouTube channel, Facebook group. I'm on Instagram and uh, Apple and all those good places. I hope this finds you well. As I said, I'm Courtney Rollins. I am the host of this channel. I'm also the owner and operator of Estate Pro Service, where we help families make probate and estate planning easier while making income and creating wealth through real estate. And one of the challenges that comes up often is when someone passes away in North Carolina without a valid will. Some folks may not know or understand what happens to the property, what happens to the personal property in the houses, how to decide who gets what. And so that's what we're going to do a quick overview of intestate law in North Carolina. Shout out to one of my fraternity brothers, chapter brothers, Eddie, for helping me pronounce that word. For some reason, intestate uh, is a challenge for me. But let's take a look. Hopefully, this will be helpful to you. What will help me is if you think this is valuable, please hit subscribe, share, comment, wherever platform you're using this or finding this. It really helps me get out to many people and help people make this process, as we said, easier for them. So let's go ahead and take a look. All right. So first thing, just understanding intestate law. That is the law that dictates, that governs how property is distributed when there isn't a valid will. All right. And so this is going to give you an explanation of what each one looks like. You can really zoom into this if you're listening. I encourage you to go to YouTube to check it out, or really do some Google search or research. It should give you a graph of the details of what happens in which situations. So, for instance, for most cases, someone dies and there's a surviving spouse, but there's no children, then the spouse in most situations will inherit the entire estate. And so it'll just transfer over. Sometimes it depends on how the property is deeded, or how it was bought and how it's deeded. But quite often, the spouse will just receive the deceased person's portion of the estate. And if there is someone there, uh, they may receive a portion of it, with the remaining portions divided among the children when there are children involved. Now, if there are children, decedents, if there's no surviving spouse, but the children are left behind, then the children will inherit the property equally, as long as there can be verified that person is their child. If there are any children that pass away, but if that child has already passed away, and they have children, then the grandchildren are receiving. It can get really messy. I had a property we're about to buy, but we found out there was about 51 actual owners of the property because there wasn't a proper will in place, and there were so many grandchildren and decedents that came along, and it was really a tough nut to crack and really thing to untangle. So let's make sure we put our stuff in place, our wills, our trust, our other legal instruments, to make sure that your family doesn't have to go through this, and there's clarity and there's the ability to really have more control over your legacy. All right. Now, if the person passed away, there's no surviving spouse or surviving children, and the parents are still alive, they become the primary beneficiaries. If there's only one parent alive, then they get the entire estate. If both parents survive, then the states are divided equally. So again, you can see how this can become pretty entangled. It's really important that you receive some type of legal support in this to help you untangle it as well. So I highly encourage you to do that if you need support or want to find an attorney. I'm not an attorney and I don't give legal advice or financial advice. I'm just sharing my opinions here on my channel and from my experience. But I do have a network that I'm connected with and that could refer you out to someone who may be able to support you and provide some more clarity here. Now, siblings. If there's no surviving spouse, children, or parents, then the siblings of that person who passed away who owned the property will inherit the estate equally. Now, if there aren't siblings, then there are some laws that determine the remaining distribution based on relatives and their degree of kinship. The closer you are connected, that you can show your connection, the the more rights you have to the property when there isn't a thing in place. Now, if you're thinking about selling the property, you really need to make sure that everyone's on board, that you have all the legal owners on board, because they may be required to agree to this, or unless the court allows for a partition sale where you can sell your portion. So it's really advisable that you go ahead and get some legal counsel. Again, reach out to me and I can support you in that. Matter of fact, Estate Pro Service, we're like the hub and the wheel here when it comes to helping folks with all the supporting them, connecting them to the legal support that they need, as well as the non-legal side of dealing with property and dealing with estate administration or probate and other things. Reach out to me, Courtney at estateproservice.com. Would love to be a part of your journey. Hopefully, it'll be helpful. And yeah, so let me know if this is helpful to you. That's a quick and quick video today, and I leave all my I end as I always do, saying that this is the Life in Transitions Experts channel. That's LITE. And you let your light shine. Cheers.